Hi, everybody, and welcome back to Chapter 3. In Chapter 3, we are going to look at the way the law functions. So let's start with just a basic definition of what criminal law is, which is rules and regulations for what is illegal and what the consequences are for breaking those rules. I want to contrast this with what civil law is. Civil law is law that manages disputes between individuals, but also it's family court. They perform evictions. They perform protection from abuse service. There's a myriad of things that fall under the rubric of civil law. Torts also fall under civil law. And torts are lawsuits that happen over wrongful acts and injury of a private or a civil wrong. These can be very controversial. Tort reform has been something that's been discussed forever, that these are the lawsuits where people win huge settlements, and there has been a lot of discussion about should people be able to get these giant, what we call lottery settlements, or should there be a limit, or should there be a cap? But torts fall under civil law as well. I want to talk a little bit about case law. Case law constitutes legal outcomes that are the result of judicial decisions from previous cases. This is also referred to as precedent. So when a judge or a jury or a case in general decides a certain standard of law in a certain case, it becomes a benchmark, which we call precedent, and we refer to it in similar subsequent cases. Stare decisis is a really fancy term that we use, in which we recognize previous case law to decide future decisions, right? This makes the criminal justice system predictable, and it provides continuity in court settings. So stare decisis is a term I want you to know. I want to start talking about categories of crimes, and we're going to start from the least serious and work our way up to more serious. So first we have infractions. Infractions are just minor violations. It doesn't rise to the level of a criminal violation. These are things like speeding, jaywalking, etc. Things that we can't allow people to do willy-nilly because it could cause harm in society. But at the same time, it's not a big enough harm, and there's not enough damage that we don't want to warrant legal action for something like that. So we define those as infractions, and the sanctions for infractions are very minor, typically fines of some form. Next, I want to talk about misdemeanors, which are your minor crimes. These crimes are less violent in nature. These are crimes that are punishable by less than 1 year in prison. And it's more likely that you're not going to land in prison with a misdemeanor, especially if it's your first offense. Misdemeanors, the system generally tends to use more diversionary sentences or suspended sentences, meaning that you're going to do something like community service. A suspended sentence is where they will give you a sentence and then say it's suspended, meaning that you don't actually have to do any time in jail, etc. After misdemeanors, we have felonies, which are the most serious crimes. These are punishable by at least 1 year in prison, all the way up to the death penalty. Right? So these are our violent crimes, crimes where there is serious damage to the victim or to society, things that we certainly can't allow people to be doing, which is why we give them harsh consequence. After felony, I like to introduce the category of treason. It's not something we hear about often, but it is its own category because it is one of the most two serious offenses that an individual in the United States can enact. Treason, formal definition, are actions to help a foreign government to harm the United States, and or any attempt for an American citizen to overthrow the United States government. Treason is punishable by the death penalty here in the United States at the federal level still. Often treason, sometimes not always, but is presented with, people engage in treason by engaging in espionage. And I want you to know what espionage is. It's interesting. It's fun. I have a video up for you to review. This is where all the great spy movies of Hollywood came from, is the practice of espionage, which is gathering, transmitting, or purposefully losing information related to the United States national defense in a way that benefits a foreign agent. Or in a way that would harm the United States. So espionage. Followed by the next we're going to discuss is inchoate offenses. And this is an offense not yet completed, but that is in the process of heading towards completion of the act. So an example of that would be like conspiracy to commit murder. You haven't murdered somebody yet, but the conspiracy is the planning, the organizing, the getting the materials. It's not done yet, but you're on your way. Okay, so that's an inchoate offense. No introduction to criminal justice class would be worth its salt without a discussion on actus reus and mens rea. These are our fancy schmancy terms to discuss intent and guilty mind. So let's start with actus reus. Actus reus is any violation of the law. It's your guilty act. Okay, actus reus, your guilty act. Versus mens rea, which is the guilty mind, your mental intention to engage in a crime, your intent, your motive. Okay, not all crimes require mens rea. I want you to keep that in mind. An example of a crime that would not involve mens rea is something called a strict liability crime. Strict liability crimes mean that it does not matter if you knew you were breaking the law. You are held accountable regardless of whether or not you knew what you were doing is illegal. The most demonstrative example of a strict liability crime is statutory rape, right? That, somebody gets arrested for statutory rape and says, hey, I'm an adult male. She told me she was 25. She looks 25. How was I supposed to know she's 16? Right? Doesn't matter if you know or not, right? You know that you're not supposed to be doing that. And the onus is on you to make sure that you are not violating that law. It doesn't matter what she looks like. It doesn't matter what she said. It is a strict liability crime. You have liability regardless of what you intended or didn't intend, what you knew or didn't know. Next, I want to move on to defining for you what ex post facto law is. Excuse me. An ex post facto law is basically, a standard that says you cannot punish actions that have already happened after a law was enacted. I know that's a mouthful. I know this is a little bit challenging to wrap your brain around, but really what it's saying is, if today I legislate something as illegal, from today on, I can arrest you for it and punish you for it. But from yesterday and all the days previous, if you engaged in that behavior, it wasn't illegal then. I didn't make the law yet. Therefore, I cannot retroactively apply that law to you and give you consequences because you didn't know it was illegal because it wasn't, right? So that's what ex post facto law is. It's basically saying that the law can only be applied from the moment it was legislated forward. You cannot retroactively apply the law and punish people for something that wasn't illegal at the time. People have a little bit of a hard time sometimes wrapping their brains around that. Okay, I want you to know what corpus delicti means. This is the body of crime, the fact that a crime has occurred. You cannot pursue somebody for a crime you think has occurred, but for which you have no basis to know whether or not it actually occurred. So, for example, if someone were to disappear and never reappear without a body, it's very, very difficult to prove that that crime happened, right? How do we know that this person didn't just leave and not tell anybody? It happens. It's strange, but it happens. We may have strong suspicion that there's a crime, but you can't assert that and pursue it without actual demonstration that the crime has occurred. I want to go over some defenses here, some legal defenses of when accused of a crime. First is an alibi, which you're probably familiar with from television and movies. This is where a defendant or the accused is truly innocent. They can give you documentation or witness testimony to say, at the time the crime occurred, this is where I was not anywhere near the crime, and therefore I am truly innocent. So that's what an alibi is. We also have justification defenses, and justification defenses are when you admit to doing the crime, but you present reasons as to why you're not culpable for it being a crime. The most common one that you're probably familiar with is self-defense, right? If you kill somebody or you harm somebody in the act of defending yourself, yes, you did that behavior, but you are not legally culpable because let's say they were attacking you. They came after you and you acted in self-defense and you killed them while you were defending yourself. If you hadn't defended yourself, they would have killed you, right? That is a justification defense. That is self-defense. Necessity is another example of a justification defense. Necessity is when you were forced to do it. You literally didn't have a choice. There's a really good Netflix documentary out there, and I can't remember what it's called, but it's about a pizza delivery guy who he delivered a pizza and these people literally strapped a bomb to his neck and said, if you don't go and rob this bank, we're going to detonate the bomb. Well, I would argue that's necessity, right? He didn't really have a choice. It's either that or his entire head was going to be blown off. So necessity. Consent. Consent. The example and that your textbook uses is really, really good. In fact, I'm old enough to remember hearing this aired on the news when it actually happened. But there was a man who was arrested and accused of rape. He was a complete stranger to the victim. And this was at the height of the AIDS epidemic when we had very little treatment, and AIDS was essentially a death sentence in a short period of years for people who contracted it. The victim requested as he started to rape her, could you please wear a condom? He argued, therefore, that made the sexual engagement consensual. Right? She argued, absolutely not. I don't even know the guy. It's a stranger rape, first of all. I just don't want to get AIDS. If you're going to do this, I don't want to get sick. Could you please wear a condom? So, consent is the defense that person went for. It failed miserably, thankfully. He did not, that was not a justifiable defense. But that is an example of consent if it had actually happened that way. Insanity. Now, this one is dicey. Everybody's heard of this one, and I want to make the distinction here. You can be mentally ill, but as long as you understand that what you're doing is illegal, then you are still held accountable. You have to, for an insanity defense, you have to be able to demonstrate you literally did not understand the difference between right and wrong at the time you were executing the offense in order for insanity to be a justification defense. This is actually, statistically speaking, it's a very rarely successful defense. It's very, very difficult to successfully demonstrate an insanity defense, even though people seem to think you can all the time. Finally, I want to pivot to procedural defenses. Procedural defenses, I'm going to give you examples of 5, and the first is going to be entrapment, right? Entrapment is an illegally induced crime that it was induced by law enforcement, meaning you, the individual, never would have engaged in the crime if law enforcement hadn't approached you and induced you to do it, right? A commission of a crime you otherwise would not have committed. A really famous example of this would be White Boy Rick. Great documentary, great movie out there with Matthew McConaughey, by the way. But essentially, he's an underage confidential informant for the federal government. He was a drug dealer, and he was a juvenile. And basically, they said, look, we know you're a drug dealer. You got to keep on doing this, that, and, all of the illegal things so that you can keep feeding us. And at one point, he wanted to get out of the criminal life. And they said, nope, you got to keep going. Right? So that's a form of entrapment. Double jeopardy. Double jeopardy. If you have already been convicted of a crime, you cannot be tried for that same crime again. That is a Fifth Amendment violation. We are very fortunate to have the protection against double jeopardy. Not every country does. Talking to you, Italy, and Amanda Knox. Denial of a speedy trial. There's a time limit from the point of arrest to the point where they must try you. That is a Sixth Amendment protection. And if that time limit, which is, yes, somewhat gray, but if we've got to put a number on it, we're generally talking about 12 to 13 months, right? If they keep, if they don't get you your trial in that time, you are now violating the Sixth Amendment. And if they do that, if you're being held prior to trial and that time elapses and you make that argument, well, guess what? If it goes to court, the judge is going to say, yep, state had plenty of time. They didn't bring this in time. It's violating the Sixth Amendment. Therefore, all charges are dropped. Go on home. So denial of a speedy trial is a procedural defense. Prosecutorial misconduct is a big one, really big hitter, where prosecutors knowingly have exculpatory evidence against the accused, which is evidence that demonstrates their innocence, and they hide that, right? They hide it to get the conviction anyway. Right. So anytime they allow false testimony or they suppress exculpatory evidence, that can result in a vacated conviction. And finally, police fraud. Police fraud is another procedural defense. The planting of evidence to boost numbers or framing an individual that they don't like or who they think will eventually cause trouble, etc. If you can prove that, that is another procedural defense. All right, I'll see you guys in chapter 4.